right, ma'am, you're Shay Morgan?
Yes, ma'am.
And Ms. Morgan's charged with theft of property and cause number 24 DCCR 2102. Mr. Gertz?
We have an offer for resolution in the case. Ms. Morgan has indicated initially that she wants to go to trial, but she's got a number of things that she wants me to look at in terms of evidence. She wants me to present to the state prior to rejecting the very, I think, reasonable offer that the state is making, or the reasonable option that the state
So
has
here's the
given us.
thing, Ms. Morgan, I'm going to address you on this. Mr. Gertz has been your attorney for over 6 months now. So if there's information that you think is important, you should have been getting that to him 5 months ago. So I'm going to reset the case one more time. This is the last reset. So whatever information you need or get to him or think is important, get that to him so he can get it to Ms. Malfino. And at the next court date, if there's a resolution, great. If not, then we'll get it moved to the trial docket.
Okay, thank you,
Okay?
Judge.
All right, you're free to go. All right, so Mr. Spites tested positive for THC, and so obviously sometime within the last 30 days or so, he's used marijuana, because typically that's how long, which means that he used marijuana after he pled guilty on a felony. He pled to an enhanced second degree. I've got pages of criminal history here. And you would think, Mr. Spites, that based on what Ms. Hawkins is telling me about your family situation and your children, that you would be able to figure this out on your own and stay clean so that you didn't, number one, go to prison. I don't even have to accept this plea agreement. I mean, you've got 3 prior convictions, a state jail felony from 2019, from 2019, credit debit card abuse from 2021, and then an unlawful possession of a firearm in 22. None of those cases did you receive probation, which is probably why Ms. Malfino made that offer to try to get you on the right track. And Ms. Hawkins did a great job of getting you a probation offer on your case, or cases.
If I may,
Yeah.
part of the reasoning behind that offer that Ms. Hawkins and I discussed was that jurisdictional type issue that she addressed with the court, and also the fact that there ended up being no restitution that's owed to any individual.
Okay, and I appreciate that argument that Ms. Hawkins made, but it's also important, and I would hope that other judges in other counties would find it just as important, that if you're going to get charged, wherever you're going to get charged, that they take into consideration that just because you didn't steal from someone in our county, you stole from someone in some county, right? And so we got you here, but somebody's a victim. And it's important to me, and hopefully important to every judge in the state of Texas, that we kind of look out for each other in each other's counties. So I get that you were just traveling through, probably lucky that we got you, because who knows what would have happened at that point if you ever would have gotten caught. And that's not fair, no matter what county the crime is actually committed in. Does that make sense? Based on everything that is being offered to you and what the pre-sentence talks about with regard to drug usage, the only way I'm going to go forward with this is with some inpatient ISF up front. So it's not necessarily meant to be a punishment. It will probably feel like it a little bit, but if you're going to be successful in the rest of your life and be there for your children, then you got to figure out how to stay clean and make some better decisions. So that's what's going to happen today. Any reason not to go forward with sentencing at this point?
No, Your Honor. No, Your Honor. Just my only concern with that is the other pending cases in Fort Bend and Joseph County. I don't know if I simply take it.
What are the court, or do you represent them in Fort Bend?
Not
And
Fort Bend, Judge, no. I have his attorney's information up there.
and what about the Harris County?
I do
That abating?
I do represent him in Harris County.
I just don't, trying to think of logistically, because one thing that I can do, I'm just not inclined to let Mr. Spites walk out today on a probation when he tests positive with this kind of history and with technically 4 felony cases pending in 3 different counties. So,
I have to ask Judge, my next question was going to be, is there typically a report date that could be given for ISF from the attorney's office for it?
Nope. And so what I'm going to do is I'm going to order it. And then once he's in custody, if you'll let obviously Harris County know that he is in custody. And if they will put a hold on him and come get him, I'll release the ISF hold while he goes and takes care of with that. Same thing with Fort Bend. But then if those are going to be probations or whatever happens, we'll put our hold back on once he's gone. So that when he finishes those counties, we've still got him for ISF. Sometimes what happens if that process takes a really lengthy time, then potentially if I feel like it's a good enough time, then I can hold that at abeyance at that point and require something like JCDI, which is outpatient. But based on the positive drug screen today and based on this criminal history and what all's pending, he's not walking out of here today. So we'll do it that way. If you'll get with his attorney in Fort Bend County, the sooner they get something set and get a hold on him, the better. Okay, that way he can get transferred, get those cases taken care of.
And I'll reach out to those DA offices, Judge.
Perfect.
Maybe with the court's order, they would be willing to negotiate their
Something
cases.
quickly.
Yes.
So, Mr. Spites, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine. There is no restitution. And you're ordered to enter and successfully complete. Mr. Spites, talk to her in a minute. Just listen to what I'm saying, okay? You're ordered to enter and successfully complete the substance abuse track of the ISF program. And if you do all of this, this is a great opportunity for you. I know it doesn't feel like it today, but you have a great opportunity in this case, number one, without another felony conviction, and to be able to serve any sentence while you're out on probation. I want you to make sure you understand, though, what the consequences could be if you violate this probation. So if you choose to smoke marijuana again or not show up for an appointments or whatever it is, then you're looking at not just a sentence of the theft of property, which is the 3rd-degree felony. You pled to an enhancement, which means if you violate, you could be found guilty and sentenced to prison for anywhere between 2 years and up to 20 years. So I'm trying to keep that from happening and give you some tools so you can be successful. I'm handing you the trial court certification that shows this was an agreement. I followed it, and so you've waived your right to appeal. You can go back with the bailiff. Ms. Hawkins can visit with you back there, okay? Yes, sir?
Okay. The fact that, all right, y'all taking me in, that means like I can't get out from here. How can I get out so I can be able to handle Fort Bend?
We're going to let them know that you're in custody, and they'll come transfer you over there from our custody.
Okay, so that's what I'm saying. That's what I'm trying to understand. Okay, if I'm on bond with them, like how would that work?
Ms. Hawkins can explain it to you, okay? All right, you can go back with the bailiff. Thank you, Ms. Hawkins and Ms. Morgan. Lawrence Jackson, are you sick right now, Mr. Jackson?
No, ma'am.
Yeah, pull it down so I can hear you better for now. Thank you. And Mr. Jackson was previously in court in cause numbers 24 DCCR 1669 and 25 DCCR 0189. Entered pleas of guilty on each of those cases of driving while intoxicated, 3rd or more. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yeah. Yes, sir.
Are there any additions or corrections?
Yeah. Nothing.
I guess this is just somewhat lucky because one happened before the other one was All right, Mr. Jackson, I'm going to follow the agreement that you made with the district attorney. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. I'm going to find sufficient evidence in each case to find you guilty. In cause number 24, DCCR 1669, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which includes entering and successfully completing the safety program. In cause number 25, DCCR 0189, also find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. Sentence you in accordance with that agreement to a term of 10 years in prison, but suspend that, place you on probation for 10 years. You're also ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation, including entering and successfully completing the safety program. If you do everything that you're supposed to on these probations, and you're successful, then for all practical purposes, your case here in court is over. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation at all, you can be brought back into court and you can be facing that 10-year sentence that you've already agreed to. Do you understand? I only have one, I don't know if y'all can get to it. I need the certification in 1669. I'm going to hand you the trial court certifications in each case that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's okay. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. We'll get that.